Thank you, Mr. President. Senate Bill 330 amends two sections of the West Virginia Code, Section 1 and Section 7 of existing code within Article 5G of Chapter 21. And Article 5G of the code is the West Virginia Workplace Freedom Act. It is the right to work bill that this legislature passed last year. After the legislature passed this bill, there was a legal challenge filed to the legislation, and that litigation has been pending for some time in the Circuit Court of Kanawha County. The case is styled as West Virginia AFL-CIO and others, plaintiffs, versus Governor Earl Ray Tomblin and others, defendant. And on February 23rd, which was last week, the judge of the Circuit Court of Kanawha County issued an opinion in that case, an order granting a preliminary injunction. The issues raised in that case were a couple different ones. One is a constitutional question. That is not addressed by the legislation that we have before us, and quite frankly, I'm not sure it could be, because under the doctrine of judicial review, the judgment of the judiciary as to the constitutionality of a legislative act is the judgment of the final arbiter. In our constitutional scheme and hierarchy, the judiciary has the final say on the constitutionality of legislative acts. Another issue that was raised in the pleadings in the Circuit Court and addressed by the court in its order entered just last week surrounded whether or not a portion of the statute was ambiguous. The court found actually that it is. The court found that our statute was ambiguous in Chapter 21, Article 5G, Section 7A, subsection 7A. And so actually part of the court's finding on that subject says that someone reading the statute has no certainty of understanding whether the so-called right-to-work legislation applies to collective bargaining agreements or negotiations or agreements within the building and construction trades. And the court went on to say if it does apply in some manner, then why is this subsection necessary, etc. So the main purpose of this bill, Senate Bill 330, is to eliminate from the Act, the West Virginia Workplace Freedom Act, the portions thereof that the court found to be ambiguous. As I mentioned, there are only two sections from the Act that are within this bill. The first is a definitions section. So in Section 1, which is definitions, we strike from the definitions section the definition of state, it being essentially extraneous to the bill. And then in Section 7, which is the section that addresses construction of the Act, we're striking subsection A, all of it, which is the language that the court specifically found in its opinion issued last week to create an ambiguity in the Act. The bill also makes it clear that the changes made this year in this bill, if it's enacted, are to be applied retroactively. Mr. President, I'd be happy to try to answer questions about the legislation. Otherwise, I urge passage of the bill.
Further discussion? Further discussion. The senior senator from the 17th.
Thank you, Mr. President. Will the senator from Oregon yield?
The senator yield. The senator does yield. The senator may proceed.
Senator, I understand what the purpose of the bill is, trying to clean up these sections that there was some potential confusion about. But why is the bill going to apply these changes retroactively?
It was our opinion in drafting this bill that because it is a clarification of what the legislature's original intention was, that it made sense to have it apply retroactively. The original bill that we passed last year had an internal effective date for contracts on or after July 1, 2016, and made sense to me that since we're trying to resolve what was simply an ambiguity, according to the court, in our enactment, it makes sense to apply it retroactively.
How do you think that that language of applying it retroactively will affect what's going on in the courts right now?
I don't think it will, but here's what I know. I know the suit was filed last year, sometime in the second half of the year, I think, after our bill became effective. And at a hearing, maybe the order tells me the date of that hearing, but the hearing was in the fall, August 10th, 2016. The court announced that it was going to issue a temporary injunction, and this order from February 23rd is, in fact, the order that memorializes that announcement. So I don't think it's going to have an effect upon anything that's happened since this bill became effective, which the act itself, the application of the act, has effectively been enjoined by the court since August of last year.
Well, I guess that even, further exemplifies my point. If you don't think it's going to affect anything in the courts right now, I guess I'm concerned about why that language is in there. Again, I agree with trying to clean up the language in the current code and make it a little more clear, but the retroactive part is what I have a little bit of concern about. And you're saying it's in there, but you don't expect it's going to impact what the court does going forward, so I guess I'm a little bit confused about why it's in there in the first place.
And I think it's in there just to make it clear that what we're doing here is not changing what we thought the law was, what we thought our enactment was, but to saying this is what we thought it meant from the beginning, even those parts which are now stricken, which the court had determined had some ambiguity in.
Okay. Thank you, Senator.
Thank you.
Further discussion? Further discussion? If not, the question before the bill will pass. All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, there being 22 yeas, 12 nays, 0 absent and not voting, more than a majority of those present and voting having voted in the affirmative, I declare the bill passed.
Thank you, Mr. President. I wanted to talk a little bit more about workplace freedom, and it was sort of, the constitutional question sort of outside the bill that we just sent out of the Senate, Senate Bill 330. But there is a constitutional question pending, and I want to take this opportunity to talk a little bit about it. In the decision rendered by the Circuit Court of Kanawha County in the case that I described a moment ago, the legal challenge to the state's right to work bill that we passed last year, the court found that the right to work law was an unconstitutional taking. The language in the court's opinion said the unions have a duty to fairly represent all members of the collective bargaining unit regardless of union membership. Indeed, providing services and negotiating, enforcing, and administering contracts costs money. Requiring unions to provide services to free riders while simultaneously prohibiting unions from charging for those services necessarily take union funds and directs them to be expended on behalf of third parties. Ultimately, the court adopted that argument and found that our right to work bill passed last year is a taking. And the court would be right if what the court said were true. But what the court said, the premise, the fundamental premise underlying that argument and this decision is not true. Is not true. In the United States Supreme Court, in the case of Retail Clerks International Association versus Lion Dry Goods, Inc., and this is, nope, I'm citing the wrong case there. Yeah. The court recognized, this is a 1962 case, so it's been the law recognized by the U.S. Supreme Court for 55 years now. We'll read from the opinion of the court. Members-only contracts have long been recognized. members-only contracts. So no union has to bargain for every employee. Unions have the right to choose to negotiate on behalf solely of their members. And so the fundamental premise behind this decision of the Circuit Court of Kanawha County is incorrect. That legal position has been reiterated numerous times and upheld. I've got an NLRB opinion here from just 2010. This is Dana Corporation and International Union, others, AFL-CIO, December 6th, 2010. And it says, among the things it says, the board and courts have long recognized that various types of agreements and understandings between employers and unrecognized unions fall within the framework of permissible cooperation. Notably, employers and unions may enter into members-only agreements, which establish terms and conditions of employment only for those employees who are members of the union. That was the decision of the Indiana Supreme Court in a constitutional challenge to their right to work bill just 2 years ago, November of 2014. The union's obligation to represent all employees in a bargaining unit is optional. Is optional. So, you know, if you create the legal fiction that the union has to represent everybody, then yeah, it flows from that you allow people to receive the benefit of that without paying dues, could amount to a taking. But it's a legal fiction. The law allows members-only negotiations and contracts. And so, you know, as I said earlier when we were talking about Senate Bill 330, ultimately, the judicial branch of our government will make the final decision as to what the Constitution permits and requires. I had no problem in voting for that bill in its original incarnation, believing that it was fully constitutional and does not affect a taking of any kind from any union. Unions choose to try to negotiate for an entire class of employees, and it makes perfect sense why they make that choice, why they want to do it that way. Number one, they want dues from as many people as possible. Number two, you know, if you're a labor union, you represent only the employees who are members of the union. If someone else is able to negotiate a better employment agreement for himself, could cause problems within the membership for the leadership of the union. You know, why does this person have a better deal than we got? You know, and then the corollary question is, what are you really doing for us? Mr. President, in my opinion, the current state of the law affects a taking. When you take a citizen who has a constitutional right to free assembly, free association, and force that person to belong to an organization or pay dues to an organization to which he or she does not want to be a member, that is an unconstitutional taking. And so, again, what was disappointing to me, most disappointing to me, about the recent decision, as I read it, I didn't see any mention of this body of law in the opinion. No reference whatsoever to that Supreme Court decision from 55 years ago, no reference to any of these more recent iterations, discussions of the law. And I hope that when this matter arrives in the east wing of this building for review by our Supreme Court, and I believe it will, that they will be circumspect and review all the law that relates to this question. Thank you, Mr. President.